Start. Learned counsel has submitted that the plea of unsoundness of mind qua the appellant is untenable, not just owing to the fact that no such plea or evidence was placed during the trial or even before the High Court, but also because the appellant had no previous history of insanity as such. Full stop. In this regard, learned counsel has referred to the testimony of PW-3, the manager of rehabilitation center, to the effect that during the period of admission, the appellant's behavior was like an ordinary prudent man and he was never administered any medicine for mental illness, for no such illness having been observed nor any previous history having been given by his family members. Full stop. Learned counsel for the respondent dash state has also submitted that the plea of unsoundness of mind, if at all, could only be raised by the defense to rule out the forming of mens rea, but a case of purported subsequent mental illness cannot be raised to invoke the exceptions of section 300 IPC. Full stop. Thus, according to the learned counsel, reference to the treatment of the appellant post conviction in psychiatry ward because of the complaints of abnormal behavior is of no avail to the appellant. Full stop. Learned counsel for the respondent dash state has further submitted that the suggestions to the effect that the appellant might be having requisite knowledge but was lacking an intention to commit the crime remains untenable for the reasons, inter alia, that the appellant meticulously planned the crime by taking his children to the canal at a time when he was vested with their sole custody in the absence of his wife, he mercilessly strangulated the children one by one, and if at all an opportunity of realization were to be visualized, at least after killing the first child, he had ample time and opportunity to restrain himself and not to kill the other one. Full stop. This apart, according to the learned counsel, after gruesome killing of the two children, the appellant enacted an elaborate ploy by interacting with the persons in the vicinity and attempted to create a false narrative of drowning of the children. Full stop. In the given set of facts, according to the learned counsel, the appellant's case does not fall under any of the exceptions contained in section 300 IPC, and hence, the concurrent findings against him call for no interference. Full stop. As noticed, the trial court and the high court have concurrently recorded the findings in this case that the prosecution has been able to establish the chain of circumstances leading to the only conclusion that the appellant is guilty of the offences of murder of his sons and causing disappearance of evidence. Full stop. Though the parameters of examining the matters in an appeal by special leave under Article 136 of the Constitution of India have been laid down repeatedly by this court in several of the decisions, but having regard to the submissions made in this case, we may usefully reiterate the observations in the case of Pappu versus State of Uttar Pradesh. Full stop.